Hi everyone, my name is Sharmin Anwar. I am an attorney with Cobb Legal Aid. I am also the lawyer in the law library here in the Cobb Superior Court just down the hall. I provide free 30-minute consultations to qualifying individuals. So basically, if you've got an issue, like a family law issue or some kind of legal issue that we cover, I am happy to sit down with you and provide some legal advice or help fill out forms so long as you do qualify. And today I will be giving a presentation on divorce. Keep in mind this is just the basics of divorce. We're not going to be getting into the nitty-gritty, just a general overview. And if you have any questions, please hold them till the end. If you are seeking specific legal advice, as I'd mentioned, you could either call the Cobb Legal Aid office or you could come schedule a time with me down the hall. So Cobb Legal Aid is a nonprofit law firm providing free advice and assistance to low-income people for many basic civil issues. The types of cases that we typically handle are like family law cases, housing, education, special ed, and public benefits. So even though you guys are here learning about divorce, if you've got some other issues going on within the stuff we touch upon, feel free to give us a call. And we do serve low-income individuals, so income eligibility is linked to the federal poverty rate. So if you do call us, we'd kind of put in your information, your income, and things like that, and figure out if you qualify. So when to call us? You should call us if you're being evicted, if your landlord refuses to make repairs, if you're experiencing domestic violence, if your disabled child's educational needs are not being met, your public benefits were terminated, and of course other family law issues like divorce, custody, support, things of that nature. We screen people Monday through Thursday, 9 a.m. to 12 p.m. If you call this number, you can create an intake and speak with our intake staff. And if you want, you can also fill an intake out online, and those should be done for like non-urgent issues. If you got an urgent issue, you'd want to call. Again, this is separate from the services that I offer, which is just down the hall. And I provide free 30-minute consultations Monday through Wednesday, 9 a.m. to 4 p.m. Just a disclaimer, this is a general presentation about Georgia law. So if you've got specifics, you need to sit down, you should talk to an attorney. Yeah, so we're just gonna keep this kind of general. All right, so when we're talking about divorce, we wanna first talk about the two big categories of divorce, and it's either contested or uncontested. Uncontested divorce cases are, as the name suggests, you have kind of an amicable situation. Both parties kind of agree. The details have been figured out on the front end, and there's not much to kind of resolve, right? So the idea is that you figured out the details when it comes to like marital property, support, things of that nature is figured out on the front end, and you file it with the court. Contested, as the name suggests, it's not very amicable, right? There's issues to be decided. There's details that need to be figured out. And so in that situation, you file the case and then you figure out the details later. Most commonly, I see contested cases. That's typically the nature of it. Occasionally, I'll see an uncontested case, but they typically tend to be contested. When you're filing for divorce in Georgia, you have to have a ground that you file under. Basically, you have to have a reason for filing for divorce. You cannot just go to the courts and say, I want a divorce. The courts expect you to explain why you're seeking a divorce. And there are 13 grounds for divorce. They're listed under OCGA 1953. There's fault-based grounds, and then there's no fault-based grounds. So no fault is, as it suggests, that you're not trying to prove that any party is at fault. You're basically saying our marriage is irretrievably broken, there's irreconcilable differences. We're not trying to point fingers, we're just saying we can't work this out. That is the most common ground that I personally see as the basis for divorce. Now, there are other grounds. There are fault-based grounds, which I will list right now. There's adultery, desertion, cruel treatment, mental incapacity or impotency at the time of marriage, incurable mental illness, conviction of a crime of moral turpitude, habitual intoxication or drug addiction, pregnancy by another man unbeknownst to the spouse, intermarriage, or force when obtaining marriage. So you could certainly file for divorce under a fault-based ground, but keep in mind that if you're going that route, you have to prove it. And the most common fault-based ground we see is adultery, right? Someone cheated on one spouse. So if you're gonna go that route, you would have to show that that actually happened. This can take a little bit longer and it can be messier. Just think about it, right? If you're trying to point fingers, you're gonna maybe take a little longer to prove your point and it can get messy. So that kind of begs the question, why would someone maybe file under fault-based, right? If it's gonna take longer, if it can be messier, well, it could be for a number of reasons. Sometimes people may need it for their own mental, emotional well-being, where they say, I had my day in court and I got to show that you are the reason for the dissolution of our marriage, right? That could be some kind of peace they feel. Another thing is, well, sometimes these fault-based grounds can affect these issues that are decided in a divorce, like division of marital property, support. So these are things that sometimes a fault-based ground can affect, even custody, right? If the things that were happening at home that ultimately led to the divorce would maybe make one spouse or one party not the best for child custody, that could affect things as well. So what can you ask for in a divorce? Well, you can ask, which is the thing most people are trying to figure out, is property division, right? There's, real and personal property the parties acquired during the marriage, regardless of whose name is in it. So that's what's going to be divided up. And people ask, well, what kind of property, right? It can be real estate, bank accounts, vehicles, mutual funds, basically anything that you guys have during the marriage. And sometimes I see that where people come and say, well, we don't have anything together. And it's not as simple as that. It comes down to furniture. It comes down to no one has CDs, but CDs, things like that. Anything you really acquire during the marriage, you're gonna wanna divide up. And the rule is that property is divided equitably, not equally. And that is a big distinction we should make here. Equitable is what is fair, equal is 50-50. So Georgia doesn't follow equal, it follows equitable. And there are certain factors that a court will look at to decide, well, what is fair in this situation? Some of those factors are, what are the financial circumstances of each party? Contributions to the household? Who paid the bills? Who stayed at home and raised the kids, if there are kids? So that is, those are just some of the factors the court will look at when they're dividing property equitably. There's also division of debt, right? If the spouses have incurred debt during the marriage, you can ask the court to divide that debt as well. And like I said, the debt the parties acquired during the marriage, it's regardless of whose name is in it, because it was acquired during the marriage. One thing people ask me about is separate property, right? What about property I had before the marriage and I still have now that we are seeking a dissolution? To that, I say it's complicated. It's very fact intensive and case by case. So if you're trying to figure out, well, what would happen to my separate property that I still have now, the best thing to do is sit down with an attorney and speak to someone about how that would be handled. You can also ask for custody. So if you have minor children that were born during the marriage, Georgia is going to make you file for divorce with minor children. So when you file, you'll see, if you go to the law library, there's two different forms. They'll say divorce with minor children and divorce without minor children. So if you got those minor children, you follow that packet, and you are going to be required to discuss issues of physical and legal custody of those minor children. Just a quick distinction. Physical custody has to do with who the children are physically with, like who do they stay with, visitation. Legal custody has to do with who has the right to make decisions, major life decisions about the children, such as education, religion, extracurriculars. So that is also something you not only can ask for, but are required to figure out during a divorce. Child support also, when you are divorcing with minor children, you also have to figure out child support. Keep in mind, child support is not given, it's for the child, right? But the non-custodial parent pays child support to the custodial parent. And Georgia follows the income shared model, which basically says that it's going to look at the income of both parents when they determine that child support amount. And I also did a presentation on this, so it should be on the website. If you want more information on custody and child support, you can definitely check out those presentations. You can also ask for a restraining order, especially where there's violence, domestic violence. You can ask for a name change, so you'll see this a lot where one party will seek that their name be restored to their name before they got married. All right, divorce. These are common pleadings, basically common documents, processes, things like that, that you will see when filing for divorce and going through that process. So I think it's important to take a moment to go through each of these and explain what they are. So, verified complaint for divorce. This initiates the divorce, and it's what you file with the court. This basically explains, it gives a plain and simple statement of what you're seeking, and like I said, it starts the process. Then you've got the summons, and the summons is an order to appear before the judge. This typically, you see this when the petitioner files it, then they have to give a summons basically to the respondent that they are now to appear before a judge, right, for a hearing. Standing order, so the court will issue an automatic domestic standing order that will apply in your situation. It's designed to protect parties when a family law case is pending. This is automatic, it's not specific to your case, it's something that's just immediately issued, and you are required to follow that domestic standing order. Examples of what's included in that domestic standing order is, for example, if you've got children, like you can't really like flee without maybe getting prior consent. So it's a one page, it's pretty long, but it outlines all the different things you can and cannot do while the case is pending. Then you've also got filing fees or poverty affidavit. So if you are unable to afford the filing fees for a divorce, you can ask for something called a poverty affidavit or a pauper's affidavit. That basically says that, hey, I don't have the funds to pay the fees. Can I please have this waived? And you can fill it out. You can get a copy of that in the law library or online. You can fill it out and you basically explain your finances, your income, and why you couldn't pay the amount. You file the pauper's affidavit along with the complaint for divorce at the same time, and the court will hear the poverty affidavit, basically decide on it every Friday at 2 p.m. Then you also have discovery requests. This is, I skipped one, affidavit or service or acknowledgement of service. This basically, we'll talk a little bit about it more, but what it does essentially is when you are filing, if you're the petitioner filing for divorce, like I said, you have to notify the other party who is the respondent. You have to go through a certain process of doing it, but you could also ask them to just waive that process and just say, hey, can you just acknowledge that you've been served with this and that I don't need to go through the sheriff or a personal process server. Then you have discovery requests, right? So this is the process of going back and forth, exchanging information. Financial affidavit, this basically requires you to, it's like a sworn statement basically showing your finances, and that's important for purposes of support and things of that nature. The child support worksheet, as I'd mentioned, if you have minor children, you're gonna have to figure out child support, and you would do the child support worksheet to figure out what that amount is and what each party is responsible for. Then there's a parenting plan. This essentially is, what we talked about this, who has physical custody, who has visitation, where's the child on holidays, on breaks, things like that. You have the settlement agreement, and that just basically defines like what the parties have agreed upon as far as like custody goes, support, and then the final decree, that's basically what closes the case and says that all issues of fact have been decided essentially. So now that we went over kind of the basic, the basic documents that you're going to see, we'll talk about the process, and I'll break these down a little bit more, but I'll go over it real quick. So obviously first you file the complaint and you serve the other party. We talked about the pauper's affidavit. So if you need that, you fill that out in the beginning, file it. There's going to be the response, the standing orders, mandatory discovery, and quick side note, discovery is only mandatory in contested cases, but if it's an uncontested case where both parties have already kind of agreed on things, discovery is not mandatory, it's voluntary. You'll have status conferences, hearings, mediation, and then a final hearing trial. So a common question is, where do I file this? So the petitioner, which is the person filing the divorce, must live in the state of Georgia for 6 months before filing. So it's not like you can move from New Jersey and then the next week file for divorce in Georgia. You have to be living here for at least 6 months before doing that. And you file in Superior Court, and the county also matters, right? Because sometimes you have a situation where, both parties may live in Georgia and may have lived in Georgia for 6 months, but they're in different counties. So where do you file? Well, where other party lives, if they're in Georgia, but if, let's say, out of state, then you file it where the filing party lives. So I'll give an example. Let's say petitioner, person seeking divorce, lives in Cobb, but the respondent, basically the spouse who isn't filing for it, lives in Fulton. You're going to file that in the Superior Court of Fulton County because that's where the other party lives. Now let's say the petitioner lives in Georgia, in Cobb County, but now the respondent, the other party, moved out of state to Tennessee. You can still file it in Georgia, and you would file it in Cobb because that's where the filing party lives. Now, something I kind of want to touch upon is, I want to get a divorce, but I don't know where my spouse lives, and what do I do in that situation? And I've seen that. You'll see people who got married, they separated, especially when there's no children involved, there's no real reason to keep in contact, but they're still married. But you don't know where they are. So what you can do is you can do an affidavit of diligent search, and you can fill that out and try to do service. And this kind of goes in with service, so we'll talk a little bit more about it. But you can still file even if you don't really know where they are. So we'll talk about the affidavit of diligent search in a little bit. But just to say, if you don't know where the other party is, there is still an avenue to go through the divorce process. This is the most common question I get. How long will this take? And a lawyer's favorite response is, it depends. It really just depends. It can be a minimum of 31 days. It can be several months. It can even be years. And let's talk about why this varies. It varies because it depends on the nature of the case. Was it contested? Was it uncontested? We can imagine an uncontested case is going to be resolved much more quickly. Are there minor children involved? Are there significant assets? Is there significant marital property? If you've got minor kids and you guys can't seem to agree on custody, or there seems to be issues with people disclosing their finances when it comes to support, that can delay things too. If you are trying to go through a fault-based ground too, right? You're trying to prove this, and so that can delay things as well. If you've got, like I said, significant marital assets and property, and you can't seem to agree on how to divide it, that can also delay things. I was talking about this just a little bit before, so service of process. So as I had mentioned, whenever you're filing something, you have to serve the opposing party, right? So you can do it by personal service by the sheriff or an authorized private process server. Most people, as an initial step, will just use like the sheriff to serve, but you'll see where people are dodging service, right? People will do that. So you can also try to use a private process server. It's a bit more costly, I think, but not significantly more. And you may have some luck with using them. Now, let's say you know where that last, because what they do on the summons, they ask you for the last known address of the other party, right? And let's say like you're in one of those situations where like, wow, I haven't talked to the other party in years. I think that's where they live, but I don't know. And let's say you really have tried your best, you can't seem to find them. You can do service by publication. So if you do not know the other party's address and cannot find them after a diligent search, the court may allow service by publication. So you would submit a motion, you would do the affidavit of diligent search, and then a publication fee. And the affidavit of diligent search is not complicated. What it basically asks you is to list out people that you know in common with the other party. So for example, if you know that other party's parents, if you know their siblings, if you know their friends, it's gonna ask you to contact those people and say, hey, have you heard of John? Have you heard from him? Do you know where he's living? And if they say, I don't know, and the affidavit asks you to write out, what did you learn from that person when you contacted them? And if you can show that, look, I contacted all these people that I know the other party, and they still don't know, they're not able to tell me where he is, then you could likely try to get a diligent search. You could try to get it done by publication. This is very tough. It is a high threshold to reach, so keep that in mind. Sometimes people will try to say, I just want to do this right away. No, you have to make the effort. You have to try to figure out where that person is. So after the complaint has been filed, and after that person, the other party has been served, they have to file an answer. So if you are the one served with the complaint for divorce, you have to file an answer with the clerk of court within 30 days of the date of service. So the answer is basically your chance to explain your side, right? Or if like you can basically admit, deny, whatever it is to the other party's complaint. And so you have to do this within 30 days. Please keep that in mind. This is a strict deadline. You want to follow it. And remember, it's 30 days from the date of service, not from the date that it was filed. And you would send a copy of the answer to the opposing party, or if they have counsel, then to their counsel. We've gone through the process of filing the complaint. We've gone through the process of serving them, and now the other party has filed an answer. What comes after that? You go through the process of discovery. And as I've mentioned, in uncontested cases, discovery is not mandatory. It is mandatory in contested cases. It can take 6 months in contested divorces, so that process alone can take a while. And it's basically the process of exchanging evidence and answering questions. The purpose really is, especially where you have one party kind of like being suspicious, maybe not really sharing their finances, you don't really know what's going on. Discovery is that opportunity to say, hey, you have to follow this because it's required by the court and by the process to turn over this information and share what you know and what you have. So yeah, that's the discovery process. After that, then you have mediation. Again, it's not really super important in uncontested cases because the idea is it's already sort of resolved. But in contested cases, if you're unable to resolve it in mediation, then the case goes to trial, right? And in mediation, you basically have a third party who's supposed to sit down and try to work with you on these different issues. The mediator is not supposed to take anybody's side. They're just supposed to sit down and try to say, all right, what do you decide on this? What about this? What about that? But you have the final hearing. So under Georgia law, a divorce may be heard by a judge or a jury. Each side will present their arguments, and the court or jury will render their decision on granting the divorce and the details of the property, custody, and financial support. That decision is final unless there are procedural grounds to appeal the outcome. You can't appeal the outcome if you don't like the outcome, if there's no procedural grounds for it, right? I've literally had that happen before where someone says, I'm appealing this because I don't like what was decided. Well, was there a problem in the procedure? You can't just go and say, not happy. There are other ways to kind of handle the final outcome, and we'll talk about that in a minute. Now, the jury, there's lots of issues to be decided, right? We talked about the different things that can be decided in a divorce case. In Georgia, there are only so many issues that the jury can decide in a divorce case. The law limits these issues to property division, alimony, and child support, but the issue of child custody can only be determined by a judge. So keep that in mind as well. Other requirements. So you would be required to sit through a family law workshop. This is basically where an attorney will go over the whole process, kind of similar to this, but a bit more maybe in detail. And I think, I don't know for sure, but I think at the end of the workshop, there's like a list of attorneys that they may provide that you could possibly hire for representation or assistance. And then if you've got minor children, then there would be a seminar for divorcing parents. All right, modification. So we were talking about what happens if you don't like the outcome, right? Well, if the idea tends to be if we've decided on this, we went through this whole process that usually is never really great. I don't really ever want to deal with that person again, right? I never want to be in court with that person again. But life happens, things change, and people may need to change the order. They may need to seek a modification, right? Common divorce modification petitions filed are to amend the terms of child support payments, child custody or visitation, and spousal support or alimony. So that's common reasons why someone might try to seek a modification. Keep in mind, there is a time limit. Like you can't just, it's like if you just got resolved and like 2 months later you try to seek a modification, that's really, really tough. Typically, you would have to wait at least 2 years to seek a modification, but there are exceptions, right? If there's like, especially when it comes to custody or child support, if there's significant changes in your circumstances and finances, then maybe you don't have to wait those 2 years. There's these exceptions like divorce modification is based on involuntary loss of income. That's important. That's a lot. Involuntary loss of income. Someone may say, I don't have the income that I had when we decided on the child support alimony. And because I don't have that income anymore, I want things changed. I want the amount changed. But that really only works if it's an involuntary loss of income, if in fact this was not kind of something you chose or you're responsible for. What happens when a party chooses to become unemployed, right? So let's say a mom was working and then she decides, you know what, I had another baby and now I want to stay home because I want to take care of the baby. That technically in some situations may be considered a voluntary loss of income, and the court may assign a salary to her because it may say that this is not a involuntary loss of income. Of course, this is something that's case by case. It's something that can happen, not necessarily will happen. Another example is non-custodial parent has failed to exercise visitation granted in the court order. So for example, if one parent was given visitation every weekend and is just not showing up, that can be a problem and you can seek a modification. Non-custodial parent has exercised more visitation than granted in the court order. That's also important. Sometimes it happens, right, where you have a court order and one parent is just maybe, for whatever reason, maybe leaning on the other parent more to take care of the child, pick the child up. I see that. I've seen that just recently where one parent will say, I was really just supposed to see my baby X amount of times during the court order, but the other parent just always needed help, always needed couldn't get off of work or had this or had that, and so I'm having to do more. So you could seek a modification. And kind of talking more broadly about why do people seek a modification. It could be financial considerations, as I'd mentioned. Your finances at the time the order was issued may have changed. It may have changed for the better, it may have changed for the worse. I see this happen where one parent will say, oh, I found out that the other party is now making way more money because they got a new job. And so now I want a modification because that new income should change how much they pay in alimony or should change how much they pay in child support. And to that I say, be careful, because even though an increase or even a decrease may seem substantial, when you put in the new numbers in the worksheet, in the child support worksheet, it may not actually make a huge difference at the end of the day. So some advice I typically give is, okay, if one party has had a significant change in income up or down, run it through the child support worksheet first, see if there's a substantial change before you seek a modification, because you don't want to have to go through all of this only to find out that actually it's not that big of a difference. Another thing is changing needs of children. So let's say when this order was first issued, there were the children were not in school yet. Now they're in school and they have extracurriculars. Or let's say now there were, back then there were daycare expenses. Now there isn't daycare expenses. And those things can affect, support, custody, things like that. Physical relocation, this happens where one parent says, look, I just got a new job, I'm out of state. I know that the order says I have the children every weekend, but that's no longer feasible. I would like a modification now. So enforcing the divorce decree through contempt of court order. So what happens when basically one party is not really following the terms of the court order, right? Not really taking it seriously, and the other party saying, they're supposed to be doing this and they're not. They're supposed to be turning the custody order says that they're supposed to give him back on this day and they're not. So what do you do? How do you enforce this? You do it through contempt of court order. So basically a party is in contempt if he or she intentionally refused to honor a clear term of the final decree. It has to be intentional, it has to be willful. Keep in mind, this is a motion, it's not a new lawsuit, so it's not like you're filing a whole new thing, it's something you file within the existing suit. And you still have to go through the process of service where you serve the other party with your motion to hold them in contempt of court order. And generally the contempt should be filed in the court that issued the order. What are the consequences of contempt? It can vary. It can be fines, it can be penalties, it can be jail time, it just depends. So because we're talking about divorce, something that kind of is unfortunately very present in a lot of divorce cases is family violence. So I just wanted to share some family violence resources. If your situation obviously involves an emergency, you would want to call 911. There's also Live Safe resources, and those services include a crisis line, counseling and support groups, shelter, transitional housing, TANF, legal advocacy, community outreach, and education. There's also Partnership Against Domestic Violence, and the contact information is listed. And then, of course, if you have just family law questions, if you need resources on family law issues, as I'd mentioned, I am in the Cobb County Law Library, which is literally on this floor, on the 4th floor, just down the hall. There's resources, there's books, you can find forms there, you can print, you can do research, you can speak to me if you need to from 9 a.m. to 4 p.m. On Monday through Wednesday. There's also the Family Law Workshop, which I mentioned. Then there's also the Fulton Family Law Information Center. So these are additional resources if you do have family law issues. If you have any questions, like I said, you can contact Cobb Legal Aid. We do intake 9 a.m. to 12 p.m. Monday through Thursday at this number. Again, you can do it online for non-urgent issues. And thank you so much.